some of them I know we have plea agreements on, and some of them I think I was told we had plea agreements on, but I don't have any paperwork on them yet. So I don't really know if there's some things to talk about or if you all just want me to work through. And then one of them is Mr. Brown, and I don't see him, Bruce Brown, I don't see him on here, but one of these cases is his. I don't know if we want to maybe, I mean, obviously.
That's my case. I can shoot him a text and see.
Yeah, I mean, we've got other things that we can be doing, so it's not like we have to wait on him, but.
Judge, we've got an agreement on Vince McAllister.
Okay.
I emailed those documents to Chrissy.
Oh, okay.
She should have it.
Yeah, we looked a minute ago and I didn't have anything, but it was about 9 o'clock, so it could have come in since then. All right, so she did have that one. Yeah, we can go ahead and go on the record if you don't care. Well, I mean, there isn't any, I have no preference to what we do first, but since you mentioned that one and I just have been handed its file, if you want to do that one first, we can.
That's fine with me, Judge.
All right. If I can find jail. There we go. Mr. McAllister,
Yes, sir.
can you hear me well?
Yes, sir.
All right. I'm going to ask you, sir, if you will raise your right hand and let's put you under oath. Okay? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. McAllister. I have in my hands some paperwork that has been transmitted to me by your attorney, and I want to go over that with you. The first thing we've got is this motion to enter a guilty plea. Can you see that?
Yes, sir.
All right. And on the second page, there would be a signature. Is that your signature?
Yes, sir.
Did you read over this before you signed it?
Yes.
Did you have all the time that you feel necessary to discuss it with your attorney?
Yes, sir.
Are you satisfied that you and he have had an adequate ability to discuss this and to communicate with one another about your case?
Yes, sir.
You understand that if you enter a plea of guilty, that has to be voluntary on your part. Another way to put that is you cannot do it just because you think somebody else wants you to do it or you feel like somebody else is making you do it. Okay?
Yes.
All right. As you appear here today, do you feel like your judgment is impaired for any reason?
No, sir.
You feel like you are under the influence of anything today?
Not today.
Are you having any difficulty understanding me?
No, sir.
All right. If something comes up during the course of this hearing and you don't understand it, or you feel like you need to ask me a question about it, will you do that?
Yes, sir.
All right. Mr. McAllister, in the motion to enter a guilty plea, it sets out the rights that you forego or give up when you plead guilty. Do you understand that?
Yes, sir.
You have the right not to incriminate yourself. And if you plead guilty, you waive that right. You understand?
Yes, sir.
All right. You have the right to a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. You would have the right to confront and cross-examine the people that give testimony against you. You would have the right to put evidence on in your own defense, and you have the right to appeal the outcome of the proceedings. Do you understand that you waive each of those rights if you plead guilty?
Yes, sir.
All right, sir. Thank you. In your case, the Commonwealth has made an offer to recommend certain things on condition that you plead guilty to certain things. And those recommendations are contained on this document. Does that look familiar to you?
Yes, sir.
And on the second page, there is a signature page or a signature line. Is that your signature?
Yes, sir.
All right. Mr. McAllister, did you read this over and discuss it, or at least have the opportunity to discuss it with your attorney?
Yes.
And by signing it, are you indicating to me that you feel like you understand it?
Yes, sir.
Let's go through that and figure out whether We do in fact understand each other. Count 1, strangulation first degree. That is a Class C felony. As part of the Commonwealth's offer, there is an agreement to amend that from strangulation first degree to second degree, which goes from a C felony to a D felony. And on a plea of guilty to that amended charge, the Commonwealth would recommend a 3-year sentence. Count 2 is assault in the 4th degree. It is domestic violence assault. That means that it is was committed against a person who is within a protected class, and that's either a person that you share a child with, or a family member, or a person that you live with in a in a romantic, you do currently or formerly lived with. That is a 4th degree assault domestic. It's an enhanceable offense. The reason I tell you that is because it's a misdemeanor now, a Class A misdemeanor, but if you get 3 offenses within a 5-year period of time, the 3rd one is a Class D felony. So do you understand that?
Yes, sir.
But this one is a misdemeanor, and on your plea of guilty, the Commonwealth recommends a 12-month sentence. 12-month sentence.
Yeah, that sounds a little bit better.
Yeah, there's a difference. You have count 3 is persistent felony offender, first degree. The Commonwealth is agreeing to a dismissal of that enhancement. Therefore, the recommendation would be a 3-year sentence on the amended count 1, a 12-month sentence on count 2, to run concurrently for a total recommendation of 3 years, plus a possible fine or costs. A condition of the plea is that you would agree not to have contact directly or indirectly with the victim in the case or the family thereof. This sentence would run consecutive to any previous sentence that you have, and the Commonwealth is opposing probation if in fact you decide to ask for it. This is how I understand the agreement. Is this what you understand the agreement to be?
Yes, sir.
All right. Mr. McAllister, other than what I just talked to you about, have you been promised anything, or have you been threatened to try to induce a plea of guilty?
No, sir.
Are you pleading guilty voluntarily today?
Yes.
Are you telling me, Mr. McAllister, that you acknowledge on or about November 19th, 2020 in Barron County, Kentucky, you intentionally impeded the normal breathing or blood circulation of another person, constituting the offense of strangulation in the 2nd degree?
Yes.
Are you also acknowledging that you intentionally or wantonly caused physical injury to Brittany Shipley, constituting assault in the 4th degree domestic violence?
Yes.
All right, Mr. McAllister, I'm going to accept your plea of guilty today. I will enter a judgment accordingly. Have you and Mr. Berry discussed whether or not you want to have a PSI done, or whether you want to go ahead and be sentenced today?
I've not discussed that with him, Judge. I would assume, Vincent, go ahead and get sentenced now, but
Let's get this over with.
okay.
Okay. You understand that you have the right to ask for this to be done in 2 different stages, a guilt phase and a sentencing phase. You can waive that because you are in custody, and you can ask me to sentence you today and not do it in 2 separate phases. Is that what you want?
Yeah, let's go ahead and get sentenced.
All right. Anything that either Mr. Berry or the Commonwealth would like to say before I sentence you?
Judge, I
I
did
don't
want
have
to,
anything, Judge.
I did want to bring one thing up. When we talked to the victim about the plea agreement, and I'm not saying that this happened, it's just a concern that I think needed to be addressed. Ms. Shipley had stated to us that Mr. McAllister's mother had called her, and Mr. McAllister had asked his mother to relay a message to her about dropping the DVO that is currently in place against him. I wanted to remind Mr. and I'm not saying it happened or didn't happen, I'm not really looking into it, but I'd like to remind him that any attempt to indirectly contact Ms. Shipley would still constitute a violation of the DVO, and I would talk to the county attorney's office if there are any other future issues.
Yeah, I mean, that's fair to bring up. I'm not making there's no evidence of that, and I'm not making any finding that occurred. But Mr. McAllister, just to get it out there, that could potentially be a criminal violation or a civil violation if that occurred, going forward. So just, you would want to avoid that. Plus, that's part of your judgment in this case, because you agreed to it, will be that you not have any contact directly or indirectly with her. So that would also be part of your judgment in this case, okay?
Yes, sir.
All right. Anything else
No,
that
sir.
anybody wants to say? No? Okay. Mr. McAllister, I believe that the Commonwealth's offer to you is fair. You know, certainly it's fair from your perspective too, because there is a, you know, an amendment of the charge. I can tell that you all negotiated and went over that. One charge dismissed and one charge amended. So I'm going to accept your plea, like I said, and we'll go ahead and sentence you to the agreed upon sentence, which is a 3-year sentence. You're going to have substantial credit, you know, up to now. I do not know what that is, but that'll, you know, we'll be sure that that gets accorded to you so that you get credit on your pre-sentence custody. Okay.
Yes, sir.
All right. As far as fines and court costs, I feel like you're going to be incarcerated at least for the immediately foreseeable future, and therefore it would make it waivable. So I will waive your fines and your court costs. I don't think it's reasonable to expect you to pay that right now. Okay.
Thank you.
Do you have any questions?
No, sir.
All right. You're good to go. Thank you. Do you all want to go ahead, since Mr. Brown logged in here, I can go ahead and take his. He's just got one case.
That's fine, Judge.
All right. That is Mr. Graves, right? I don't,
It is.
Mr. Brown might be tied up in family court. Let's make sure. Mr. Brown, are you able to get on or are you tied up? All right. We might have to come back to you, Mr. Graves, okay?
All right.
Your attorney's on here, but he was going to be doing 2 courts at once, so.
All right.
Your Honor, since Mr. Brown's not available at this time, could we, I know that I'd sent Greg and Josh paperwork on both Michael Herzog and Alicia Chevaria's case. I sent it signed, and I don't know if you all filed it and signed it or.
I've got it now. I've got it.
Okay,
I'm
All right.
sorry, he wouldn't have, Mr. Herzog. I don't have that signed yet. I'm sorry, I didn't realize we had that on this morning. So I didn't take it to the jail and go over it with him.
What, do you remember what well, let's go ahead and do Miss Chavaria and then we can figure out what we're going to do on the other ones.
Okay.
I think she's got 2 cases, a 21F 142 that she's agreeing to proceed by information, and then the existing 20 CR 221. Miss Chavaria, are you prepared to go forward today? Is there an agreement?
Yes, sir. Yes, sir.
All right, will you raise your right hand, please? Do you swear to tell me the truth, so help you God?
Yes, sir.
All right, thank you. So I got a lot, presumably you've signed these things, so you know there's a lot of papers here.
Yes.
I'm just gonna I want to go through them or at least show them to you and let you confirm to me that you've seen them and signed them, so that I can be confident that you understand what's going on. This is a motion to enter a guilty plea. Do you see that?
Yes, sir.
All right. On the second page, there is a signature. Is that your signature?
Yes, sir.
All right. There is an offer from the Commonwealth. It's on this sheet right here. You may not be able to actually read that, but does that look familiar to you?
Yes, sir.
Can you read it?
Yes, sir.
All right. And is it also signed by you?
Yes, sir.
All right. Then in your newer case, there is also a motion to enter a guilty plea, and it appears to have the same signature, but just to confirm, confirm that. Is that your signature?
Yes, sir.
All right, thank you. And there is a plea offer from the Commonwealth with, again, a signature page. Is that your signature?
Yes, sir.
Thank you. Finally, in that case, there is what we call a waiver of rights where you acknowledge that you and your attorney have talked about your rights and your options in that case. Is that your signature?
Yes, sir.
Thank you. Do you feel like you are under the influence of anything today?
No, sir.
Do you feel like your judgment is impaired for any reason today?
No, sir.
No? All right. Do you feel like you have had adequate time and opportunity to discuss both of your cases with your attorney?
Yes, sir.
Did you read over all of these documents before you signed them?
Yes, sir.
And did you get the chance to talk to your attorney about them before you signed them?
Yes, sir.
All right. Do you understand that you cannot be forced or compelled to plead guilty? And if you do plead guilty, I can only accept your plea if I find that it is voluntary on your part.
Yes, sir.
All right. Do you feel like you are being forced to plead guilty by me or by anybody else?
No, sir.
Do you understand that you waive certain constitutional rights when you plead guilty?
Yes, sir.
You have the right not to incriminate yourself. And if you voluntarily plead guilty, you waive that right. Do you understand?
Yes, sir.
You have the right to a jury trial where the Commonwealth has the burden of proving guilt beyond a reasonable doubt. You waive that if you plead guilty. Do you understand?
Yes, sir.
Okay. You have the right to confront and cross-examine the people that testify against you. You waive that right if you plead guilty. Do you understand?
Yes, sir.
You have the right to put evidence on in your defense. If you plead guilty, you waive that right. Do you understand?
Yes, sir.
All right. And finally, you have the right to appeal the outcome of the proceedings, but by pleading guilty, you waive the right of appeal. Do you understand that?
Yes, sir.
All right. In the case 20 CR 221, the Commonwealth's recommendations are as follows. Count 1, possession of a controlled substance, first degree, first offense. That is a Class D felony. On a guilty plea, the Commonwealth recommends a sentence of 2 years. Count 2, drug paraphernalia. That is a Class A misdemeanor. And on a guilty plea, the Commonwealth recommends a sentence of 12 months. Those sentences would be concurrent for a total recommended sentence of 2 years, possible fine and court costs. The Commonwealth agrees to probation for a period of 2 years on the condition that you are supervised by probation and parole. You follow the rules of probation and parole. You and in this particular instance, one of those will be that you get a substance abuse assessment, which they'll arrange for you, and that if there's any recommended treatment, you comply with it. Okay.
Yes, sir.
Your Honor, that's actually, there was a typo in the plea agreement on the CR case. She's already been evaluated by Bethany. That's in the F case paperwork.
All right.
Yeah, and Judge, I'm fine with whatever Bethany had recommended.
All right. Well, allow me to take just a second and change that to where instead of it saying she shall be assessed, I'm going to say she has been assessed by the DPA social worker. Bless you. And shall follow the recommendations. All right. How about that?
That works.
And your sentence in this case is going to be served, or would be served concurrently with the sentence in the other case in the event that you get your probation revoked. Okay.
Okay.
All right. Ms. Chavarria, other than the Commonwealth promising to make those recommendations to me, has anybody else promised you something to try to get you to plead guilty?
No, sir.
Have you been threatened by anybody to try to get you to plead guilty?
No, sir.
All right. Do you acknowledge to me that on December the 7th, 2019 in Berrien County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right. Thank you. We're going to move on to the next case. Oh, wait, yeah, we got 2 cases. Okay.
Okay.
I've already talked to you about your guilty plea, and you understand what it is that you are giving up by pleading guilty.
Yes, sir.
Rights, because we just talked about them. In this case, the Commonwealth is recommending the following. Count 1, possession of a controlled substance, first degree, first offense. It's still a Class D felony. The Commonwealth recommends a 2-year sentence on your guilty plea. Count 2, possession of synthetic drugs, second offense. It is a Class D felony. On your guilty plea, the Commonwealth recommends 2 years. Count 3, drug paraphernalia. It's a misdemeanor, Class A, 12-month sentence is recommended by the Commonwealth. Each of those would run concurrently with one another for a total recommendation of 2 years, and the Commonwealth would recommend concurrent sentencing of both of the two cases for a total recommendation of 2 years. The Commonwealth agrees to supervised probation on the same terms and conditions as in the previous case. Okay?
Yes, sir.
Is that what you understood your recommendation to be?
Yes, sir.
And other than that, have you been promised anything to get you to plead guilty?
No, sir.
Have you been threatened to induce a plea of guilty?
No, sir.
Are you pleading guilty voluntarily and of your own free will?
Yes, sir.
Are you acknowledging to me that on March the 10th, 2021 in Berrien County, you knowingly and unlawfully possessed methamphetamine, synthetic drugs, and drug paraphernalia?
Yes, sir.
All right. Ma'am, I'm going to accept your plea of guilty in both cases. And now, Josh, let's turn our attention to the sentencing aspect here. Have you discussed with Ms. Chavarria whether or not she wants to waive a PSI and be sentenced?
We discussed it briefly this morning. Correct me if I'm wrong, Alicia. You want to waive your PSI, correct?
Yes, sir.
Okay.
All right. So can anybody enlighten me and the probation folks that are on the call here, whoever is going to end up dealing with you? Can anybody enlighten me what the recommendations of the DPA alternative sentencing worker are going to be?
Bethany just texted me a moment ago, or right before we started this, and she said that it's going to be short-term treatment, and she's working on getting a bed date now.
All right.
So
So I feel like the important thing to do would be to incorporate that into this order that we do. Just because I don't want to, since we know that the evaluation has already been done, I don't want to just leave that vague and say, well, she'll just do whatever she's told to do. I'd like to put it in there. So
right.
we're going to put in there that she was assessed and the recommendation was for short-term inpatient treatment. And that's what we are going to do as a condition of probation. Okay.
Okay.
All right. So what that, I assume, but I you know how dangerous that can be. So we better talk about it too. I assume that the idea would be for her to remain in there till we get her bed.
Mm-hmm.
Yes, that's how I understand it.
All right. And that's fine. I can do that. Just be sure to keep me in the loop on when she gets that bed date.
All right, I'll email you as soon as I get a bed letter from Bethany.
It's probably a good idea also to just point out at this time that not next week, but the following week, that's the spring break week that usually everything around here, courts and everything are pretty spotty. And so, any information that we can get before that is, it's hard to get a lot done. People are taking vacations. My office staff will be in and out and not here all the time and all that. So I'm just warning everybody that could happen.
Okay.
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 All right. But I would say that we'll have something before then, because it usually doesn't take that long to find out. It may take that long. It may take more than a week to get a bed date, but it usually does not take more than a week to find out when your bed date is. So,
Right.
Ma'am, just hang in there and we'll get it done. Okay.
Yes, sir.
All right. Do you have any questions?
No, sir.
All right. Thank you very much.
Thank you.
Your Honor, do you all know anything about, I'm showing that there was a Hardin County bench warrant that she had gotten served with March the 11th also.
I am like Sergeant Schultz. I know nothing.
Yeah, I think Amy, she mentioned that to me. It's a restitution issue, and Bonnie's trying to get a court date set up so she can get it resolved with Hardin County.
Okay. I'm showing a court date of April the 12th is something that pretrials put in there, but I just didn't want that to hold up her progress.
Okay.
Thank you.
One thing, while I've got everybody mind on her, we need to let Julie Atkins know what we did, because Julie was looking for a bed for her in that case, and she called me about her this morning. And we need to tell Julie that this matter is being taken care of by alternate means. Yeah. Which I told her I thought was the case. I told her that I said she's on today. I think she's going to enter a plea today, and I think we'll take care of it. You don't have to do anything, but I'll follow up with you. All right. Mr. Bixler. All right, Mr. Bixler, how are you today?
All right, yourself.
I'm doing well. Thank you for asking. Do you feel like you have an agreement in your case?
I do.
Do you feel like you are ready to proceed with entry of that today?
Yes, sir.
All right. Can you raise your right hand? Do you swear that you will tell me the truth? So help you God.
Yes, sir.
All right. Presumably you've looked at all these documents. So kind of like the last case, you know that there's a lot of paperwork here. I'm going to show that to you and let's go through it together. Okay.
All right.
All right. First off, you have two separate cases. In 20 CR 314, there is a motion to enter a guilty plea. Okay. Do you
Yes, sir.
recognize that?
Yes, sir.
And is that your signature?
Yes, sir.
All right. Thank you. In that case, there is also an offer from the Commonwealth. It's on this document here. Does that look familiar to you?
Yes, sir.
All right. And there is a signature page. Is that your signature?
Yes, sir.
All right. Thank you. In 20 CR 349, we have two similar documents. We have a motion to enter a guilty plea. And is this your signature?
Yes, sir.
All right, thank you. And we have a written offer from the Commonwealth, which is represented right here. Does it have your signature?
Yes, sir.
All right. Mr. Bixler, did you read through each of these things and have the opportunity to discuss them with your attorney before you signed them?
Yes, sir.
Did you make sure that you understood what you were signing before you signed them?
Yes, sir.
All right. You understand that you have certain rights of a constitutional magnitude that you are waiving by pleading guilty.
Yes, sir.
All right. I need to know if you feel like your judgment is impaired for any reason today.
No, sir.
Or do you feel like you are under the influence of anything today?
No, sir.
Do you feel like you have had adequate time and opportunity to talk to your lawyer?
Yes, sir.
All right. Do you understand that you do not have to say anything that would prove the charges against you? In fact, you have a constitutional right not to incriminate yourself or say things, admit guilt or anything else. If you plead guilty voluntarily, you are waiving that right.
Yes, sir.
All right. You understand that you are waiving the right to have a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt.
Yes, sir.
Do you understand that by pleading guilty, you are waiving the rights of confrontation and cross-examination of the people that give evidence against you, as well as the right to put evidence on in your own defense?
Yes, sir.
And finally, Mr. Bixler, do you understand that by pleading guilty, you are waiving the right to appeal the outcome of your case to a higher court?
Yes, sir.
All right, thank you. Going back in the same order, 20 CR 314, the Commonwealth has made the following offer to you on your plea of guilty to count 1, trafficking in a controlled substance, first degree, 2 or more grams, first offense, which is a Class C felony. The Commonwealth would recommend a 7-year sentence. Count 2 is persistent felony offender, first degree. As part of the plea offer, the Commonwealth would agree to amend that to second degree, which enhances your sentence from a 7-year sentence to a 14-year sentence. There is also the issue of restitution of $145 to the task force. The Commonwealth would agree for this sentence to be run concurrently with your other sentence, which we're going to talk about in a minute, and the Commonwealth opposes probation. Is this your understanding of the Commonwealth's offer?
Yes, sir.
And do you in fact agree to plead guilty on the basis of that offer?
Yes, sir.
Do you feel like you are being forced by me or anyone else to plead guilty?
No, sir.
Other than the Commonwealth's offer to make those recommendations to me, have you been promised anything else to try to get you to plead guilty?
No, sir.
All right, Mr. Bixler, are you acknowledging to me that on December the 4th, 2019, in Barron County, Kentucky, you knowingly and unlawfully possessed 2 or more grams of methamphetamine, which is a Schedule II controlled substance, with the intent to sell, distribute, dispense, or transfer it?
Yes, sir.
All right. Are you also acknowledging, with respect to the allegation of persistent felony offender in the 2nd degree, that you are currently more than 21 years of age, you were more than 18 years of age when the underlying offense was committed, and you have previously been convicted of a felony in Adair Circuit Court, case number 17 CR 00155?
Yes, sir.
All right.
Was that a possession charge? I couldn't understand why they chose that one, but was that a possession charge on a dairy?
Yeah. Oh, the Adair?
Yeah.
I, to be frank with you, I don't know what that
That's
case
fine.
was. I don't have any
picked up
information on it.
felony there.
It is a possession charge.
Okay.
He was originally indicted as a persistent felony offender in the 1st degree, and he has, I think, 2 or 3 other prior qualifying convictions.
Yeah.
That was just the most recent in time.
Yeah. Mr. Bixler, that was 17 CR 155 in Adair County, possession, 1st degree, 1st offense. Received your sentence in November of 2017. The Commonwealth says that they just picked that one because for PFO 2nd, they needed 1, and that was the most recent one.
Okay, that's fine.
All right. Okay, Mr. Bixler, I'm going to accept your guilty plea in that case, and let's move on to your next one. This one is the Commonwealth's recommendations in this case are as follows. Count 1, trafficking in a controlled substance, 1st degree, 2 or more grams, 1st offense, a Class C felony. The Commonwealth on a guilty plea would recommend a sentence of 7 years. Count 2, PFO 1st degree. The Commonwealth would agree to amend that to persistent felony offender 2nd degree and recommend a sentence, which would enhance your sentence of 7 to a sentence of 14 years. The Commonwealth agrees to run the 2 cases concurrently, and the Commonwealth would oppose probation, much like in the first case. Is this your understanding of the offer in the 2nd of your cases?
Yes, sir.
All right. Other than what I just talked to you about, has anybody promised you anything to get you to plead guilty?
No, sir.
Have you been threatened by anyone to try to induce a plea of guilty?
No, sir.
Do you feel like you are being forced by me to enter a plea of guilty?
No, sir.
All right. Mr. Bixler, are you acknowledging to me that on or about March 16th, 2020 in Barron County, you knowingly and unlawfully possessed 2 or more grams of methamphetamine, a Schedule II controlled substance, with the intent to sell, distribute, dispense, or transfer it?
Yes, sir.
Are you also acknowledging to me that you are currently more than 21 years of age? You were more than 18 years of age when the underlying offense was committed, and you are convicted, you have been convicted of a felony in Adair Circuit Court, case number 17 CR 155, which resulted in a sentence of 1 year, and you are therefore a persistent felony offender in the 2nd degree.
Yes, sir.
All right. Mr. Bixler, in both cases, I'm going to accept your plea of guilty as having been entered freely, knowingly, intelligently, and voluntarily with advice of counsel. Have you all discussed whether or not you wish to have a PSI done before your sentencing, which is your statutory right to do?
We have discussed that, Your Honor. He was willing to waive that. I do have a motion for furlough to make. That was not part of the plea agreement, but I did advise Risa that I'd be making that. I think she's actually opposing that. But if I could have some time to discuss, a motion for temporary furlough, I'd appreciate that.
All right. Yeah, you can go ahead and discuss that, and then I'll hear from the Commonwealth and we'll see. Okay.
Your Honor, Mr. Bixler has taken a 14-year sentence. It's a substantial amount of time. We're requesting a 14-day furlough, and I want to tell the court a couple of things. Number one, a lot of this case was built around a confidential informant. I will submit to the court that although Mr. Bixler was given written discovery, he never asked to hear the calls between the confidential informant. So he, at this point, has no clue who that is. So I don't think there's any CI in jeopardy or anything like that on this particular case. His mom and dad had signed, well, it was actually his father had signed for a car for him as a co-signer. And one of the things he's wanting to do is try to get back with the company that he bought this car from to try to spare his dad's credit from being ruined. And he really kind of needs to be out to try to negotiate returning that car to them. Additionally, he's had a little bit of breathing problems since he's been in there, and his mom has scheduled a doctor's appointment for him for April 6th just to have him, checked out for the breathing issues that he's been having. We believe that 14 days would be sufficient for him to get all of that squared away. I've discussed in detail with Mr. Bixler that if he does not report back when the court tells him to, then he could be facing a bail jumping charge. And they also add that PFO1 back on that, and they would run it consecutive, and he'd be in a whole lot longer than 14 years. He's fully aware of that, and he's fully aware of those risks. He just would appreciate it if the court would give him a chance to get out and get that squared away with that car so that his dad's credit doesn't end up getting ruined because he was co-signing on that car. And then also to try to get that breathing issue under wraps. It may be a minor issue, and I do understand that there's nurses at the jail and there'll be nurses with DOC, but we thought if he could just head that off and just get checked out at his GP, that would be helpful to him. So that's why we're asking just for a 14-day furlough, just to get those things pretty much in line. And then he's happy to report back. He understands the risk. He understands that he'd be looking at a lot more time if he doesn't report back. I think on his pretrial report, I think he was kind of listed as either moderate or low risk, but due to his charges and his past history, he was not unsecured. But I don't really think that he's a risk to not come back in. And I don't think that there's a risk for the CI, because I'll submit to the court that, frankly, he never asked to hear the CI recording, so he doesn't know who that is. And he's represented to me that he's not sure exactly who it was either. So.
Okay. Ms. Carter.
Your Honor, the Commonwealth would have to oppose any kind of furlough in this case. Due to the nature of the case, he was charged with 2 trafficking greater than 2 grams of methamphetamine, and he's a persistent felony offender in the 1st degree. And this isn't a PFO charge where there are just 2 qualifying prior felony convictions. There are several going back to 2001. One of his most recent convictions was in Barron Circuit Court in 2014, where he took 12 years on a manufacturing case. His probation was revoked in that. You also had that 2017 case that we used as the PFO's second qualifying conviction. And in looking at that case, just briefly here, on CourtNet, it looked like he failed to appear for the preliminary hearing in Adair District Court. We initially had made an offer in this case with the PFO first, and we came down after negotiations to the PFO second. And that would mean that, he possibly he will face the parole board a lot earlier than he would had we stuck with the PFO first. However, it is still a significant amount of time looking at his criminal history. This is the longest sentence Mr. Bixler has had, and we do have concerns that he will not return to the jail due to the length of the sentence. I think as far as this loan goes, if this is a co-signing issue, I think that is something that his father would be equally able to take care of. And if there's any kind of paperwork to execute, I'm sure that the jail will assist in him doing that. And I think as far as this breathing issue, I do think that is something that corrections or the nurses at the jail can take care of. And I trust that if this is something that they feel like outside medical advice is needed in order for him to be treated, that they will take care of that.
Well, let's talk about a couple of things. And the first one is practical, and that is that if Mr. Bixler waives his PSI and I sentence him today, I can't furlough him because once I sentence him, he'll be in the custody of the Department of Corrections. And I know that we used to do that kind of thing with some, not very regularly, but I mean, it used to get done. But at least the last, few times that we tried to do something like that, the DOC, came out of the sky and put their foot down and said no. So I wouldn't want to do that. And if I did do it and it didn't work, and then it looked like, I'd sold somebody a bill of goods, I wouldn't want to do that. So for us to do that, we would have to set it off for another sentencing. The other practical effect would be that if I sentenced him and then he didn't comply with his plea agreement, there wouldn't be any avenue to do anything like reinstate the PFO first because he would already be sentenced. So, I mean, I'm afraid you would run into a procedural issue there that would be, that would end up working to the advantage. These are all hypotheticals, right? But if he did fail to comply, then it would work to the advantage of the person that failed to comply, and that wouldn't be a tenable outcome. Now, moving on to the other thing, I've done this a few times. It has almost never worked the way that it's supposed to work. I mean, these are.
Hey, Judge, real quick, I got the note right here. What I really need to do is see a heart and lung doctor. My heart, from the years of drug use, is I'm having a real rough time with that. If you want to, you can talk to this nurse. My blood pressure is like running 180 over 145. You know what I'm saying?
I'm not doubting at all the legitimacy of your health issues. What I'm saying is that I have let people out pending their sentencing, and I don't know why it doesn't work, because they do it in the federal system all the time. But the last 2 or 3 that I've done, they've either picked up new felonies while they were out, or they have failed to show back up. And I'm not going to use any names because, but there's a couple of people in particular that run the risk of screwing it up for everybody else, because after we get burned 4 or 5 times in a row, it makes it awful hard. I'm trying to evaluate your situation on its own merits and not on the merits of the last 5 guys I did it for that all screwed it up for the rest of you. But, and I'm not, like I said, I'm not going to say any names because it's kind of like saying the name of a CI, I'm not trying to get anybody hurt, but there have been a couple of them, some more high profile than others. And I mean, at some point I've got to feel like acknowledging that for whatever reason, this doesn't work the way that it ought to work. I can't trust people to get out and do what I'm telling them to do. And that seems to be universal. Yes, ma'am.
I'm sorry to interrupt you, but with the things that Ms. Myers stated that he needs to do, I know that we have someone in custody now who has regularly gotten out for doctor's appointments, and it's usually a day. And I think that both of these things could be accomplished if you were to decide to furlough him, would be by letting him out for 1 day, not 2 weeks. I think that's just too long.
Well, again, we're back to the 2 things. Number one, I would not feel all that bad about doing, we have done a lot of furloughs for people and let them out for a day, or, I don't know if it's the overnight that gets people or what, but I mean, I let people out for 2 weeks and they cut their, I put them on an ankle monitor and they go to the edge of where they're allowed to go, and then they cut it off, on a dead run, moving in the opposite direction. And before you ever know what's going on, they're in another state or whatever. And, I mean, they get caught. Everybody gets caught. Right? It's just that they don't get, it's a lot of extra effort and work and time for somebody that is just gaming the system. But again, if I sentence you today, I can't do any of this. So, but what I can do is put your sentencing off for a month. And then if I can get some information about your medical appointment some confirmation of it and a date and a time and all that stuff, I would consider furloughing you to allow you to go to that medical appointment and come back.
Okay,
And I always try to give you some leeway around the time, because I don't want to put anybody in a bind. So I don't, I'm not going to let you out at 10 minutes before it or anything like that. And, you can make some calls and try to get some things done to get your loan taken care of or whatever it is. I'm really not trying to bind you up, and I'm not trying to hurt your dad either.
yeah,
But this has traditionally and historically been a bad idea. That hadn't kept me from doing it,
I understand
but
completely.
it's been a bad idea.
I understand completely. If we
Yeah.
could, let's set it off for a month and let's see if I can get an appointment.
Yeah.
Or go see a heart and lung doctor, and then maybe we can get that resolved.
I mean,
Your Honor,
I'm stubborn enough to want to trust people if they give me their word, and of course that bites me all the time. But I try, because I want to treat it on the merits of your request and not the last 5 dummies that screwed up.
Right. Right.
All right.
Your Honor, if I may, his appointment is April 6th at 9:30 a.m. with Dr. Faith Sun at the Graves Gilbert Clinic in Bowling Green. And I got that information from his mother, Chris Bixler. I know that Ms. Gardner had indicated, well, since the dad is a co-signer on the car, it ought to be able to get that squared away. But the issue is, when you're a co-signer, it doesn't necessarily mean that you're a titled owner of the vehicle. And I think what my client was wanting to try to do is either trade that car back in. He just doesn't want his dad to be stuck with that loan. And you know how car companies are, that's what they'll do. They'll come after him, and he's not going to have, you don't get ownership just because you co-sign for a car. So what he was wanting to try to do was either trade that car in or sell it right quick so that his dad isn't stuck on that. So we were thinking that might take a little bit more than just a phone call.
Sure. Yeah, I mean, they're not going to come after him because they can't if he's in prison, they can't get money from him. So
They'll go after his dad, and
that's-
he doesn't want his dad to, bear the brunt of his actions. So I think that's what he was trying to do, and be honorable about that. But he does have that appointment. The soonest appointment we could get him in for was April 6th. We were actually trying to get him in something sooner, so that we didn't have to ask for a long furlough period of time. But that was the quickest appointment Miss Bixler could get for him.
Yeah. All right. So here's what let's do. Let's put Mr. Bixler's, he indicated before he was waiving a PSI, but I'm not going to accept that waiver, and we'll set him for a sentencing on April 26th at 10 a.m. For a PSI to be done. I will, I'll at least get him a furlough to go to that medical appointment. Mr. Bixler, your attorney said it, and I said it or alluded to it, but you need to know that if you screw up on that furlough, I know you know it, but I mean, at least if you do screw up, I'm going to feel comfortable that I explained all of the downfalls to you before you did it, right?
Sir.
Because you're a grown man, and I mean, I can't keep you from screwing up, but you need to know what the consequences are. That PFO first will be reinstated. All right. Not only that, but the concurrent recommendation of the Commonwealth running these 2 concurrent, I can ignore that.
I know.
And you can get bail jumping, which would by definition be tacked on consecutively to any other sentence.
I
Okay.
understand.
So, 14 years is not a short time, but it's a heck of a lot shorter than what it will be if something else goes on. Okay.
Understand.
And I mean, for me to be doing my due diligence, I want to get it out there
Got you, man.
so that you understand.
Yes,
Okay.
sir. Yes, sir.
All right. I'm going to see you on April the 26th. I'll think about this other thing, and I'll get you out to go to your doctor's appointment, and I may let you stay out the whole day or get out the day before or something like that. I mean, I'm just going to have to think about it. I don't know exactly what I'm going to do.
I mean, I think he could sign it over to his dad, or at least effectuate some paperwork so someone on the outside can help him sell it.
Yeah, I mean, we're not going to be out for a week or anything like that. I just want you to know, I mean, if you do get some extra time, you'll have to try to have a plan so that you can hit the ground running. Okay.
Got you, man. Thank you.
All right. See you.
Judge, is Greg still on here? Yes. On Michael Herzog, part of our agreement on the revocation and on this new deal was for him to go to Park Place, and I'm not sure that he even has a bed date yet. Greg, you could correct me if I'm wrong, but maybe we could do this on Monday.
I think so. I don't believe Bethany's on here this morning. I can't remember. I think I had her look into it, but I can't recall. We've had so many lately. She's
I know. I know there was one that we had in common that you had given a bed date in an email to me, but I don't believe it was Michael Herzog.
I haven't seen Bethany yet.
Okay.
Well, Greg, it doesn't seem like we would lose out by putting him on for Monday. They give Bethany time to work him out, and we'll have all three of his cases right here, and that also makes it work smoother because we'll have all the paperwork.
Okay. I'm sorry for letting this slip by. I just did not have this on my calendar.
Now, I'm pretty sure that he agrees because his dad's already called up here and said thanks for letting him go to rehab.
Okay. Okay.
And I said, well, I guess there's an agreement then. That's the first time hearing. I mean, I didn't talk to him. He called up here and left me a message. I didn't speak to him personally, but so,
Yeah,
you know,
send me the paperwork. I just haven't
Yeah.
got it
but that leads me to believe that Mr. Herzog, the younger, is on board and is willing to do that. So I think we've got a plan. It's just a matter of getting all the dominoes in line.
Thank you, Your Honor.
All right.
All right. Thank you,
All
sir.
right.
Will
See
that
you
be at
Monday.
10, Judge?
Monday at 10. All right. Looks like I need to get we still need to get Mr. Brown shook loose. All right, other than Mr. Brown's case, I don't know that we have any other pleas or anything, but if we have any, y'all let me know and we'll do them. Oh, there he is. Okay. Mr. Brown, you ready to go with Mr. Graves?
I am, Judge.
All right. Mr. Graves, can you come on back up, sir? All right. Good morning again. How are you?
All right, how you doing?
I'm doing okay. Mr. Graves, can you raise your right hand, please? You swear to tell me the truth, so help you God.
Yes, sir.
All right, thank you. Mr. Graves, I'm being told that you have reached an agreement in your case whereby you will be pleading guilty to at least one of your charges. Is that right?
Yes, sir.
Do you feel like I'm making you plead guilty to anything?
No,
Is anybody else making you plead guilty to something?
no,
All right. Do you feel like you're under the influence of anything today?
no,
Do you feel like your judgment is impaired for any reason today?
no, sir.
Have you had an adequate opportunity and amount of time to discuss your case with your attorney?
Yes, sir.
All right, Mr. Graves, this is a motion to enter a guilty plea. Does this look familiar to you?
Yes, sir.
And does it have your signature on it?
Yes, sir.
All right. This is the offer from the Commonwealth. Again, does that look familiar to you?
Yes, sir.
And does it have your signature on it?
Yes, sir.
Okay. Did you read both of these before you signed them?
Yes,
Did you have the chance to discuss them with your attorney and ask him any questions that you might have had?
yes,
All right. Do you feel like you understood what you signed?
yes,
All right. Were there any questions that you asked your attorney and he was not able to answer?
no,
All right. Mr. Graves, if you plead guilty, you waive certain constitutional rights. Do you understand that?
yes, sir.
You waive the right not to incriminate yourself. Do you understand?
Yes, sir.
You have a right to a jury trial where the Commonwealth has the burden of proving guilt beyond a reasonable doubt. You waive that right if you plead guilty. Do you understand?
Yes, sir.
Okay. You have the right to confront and cross-examine witnesses, as well as the right to put evidence on in your defense. Do you understand that you waive each of those rights if you plead guilty?
Yes, sir.
All right. You have the right to appeal the outcome of your case to a higher court, which you waive if you plead guilty. Do you understand?
Yes.
All right. Mr. Brown, I'm not trying to be a smart aleck. I'm only bringing this up because I want to, on his motion to enter a guilty plea, it doesn't have your signature on it, but did you in fact go over this with him?
Did, Judge, and I just noticed that was my mistake. I didn't sign it. But
It's no problem. I'm just going to ask you if you had this piece of paper, if we were doing this live, would you be able to sign this certificate saying that you confirm that everything in that is true?
yes, Judge.
Can I go ahead and just write your signature by me?
Yes, Judge.
All right.
Please.
There isn't any reason to let that hang us up as long as you're on here and confirming that you sent. All right. So, Mr. Graves, the offer from the Commonwealth is as follows. On count one, theft by unlawful taking $500 or more, but under $10,000. That is a Class D felony. On a guilty plea, the Commonwealth would recommend a sentence of 4 years. Count number two was a co-defendant charge, so it does not apply to you. Count number three, persistent felony offender in the first degree. The Commonwealth would agree to a dismissal of that charge. Therefore, the recommended sentence on your guilty plea would be 4 years plus a possible fine and court costs, restitution of $1,907 payable to Lowe's of Glasgow. The Commonwealth would agree to probate your 4-year sentence for a period of 5 years or until your restitution gets paid if it takes longer than 5 years, after service of an alternative sentence of 60 days, which would begin on the date of your final sentencing. Is this what you understand the Commonwealth's offer to be?
Judge, that's not my offer. He's going to get credit for the time that he's been in.
Yeah, and I was going to ask the court about that. Yeah, I spoke with Risa and she agreed that was apparently the co-defendant's offer. So I think he got MRS about 30 days ago or so from what he was serving time on. So yes, she's agreed to give him credit for any time that he's accumulated.
The co-defendant was not in custody and
I got you.
Mr. Graves has been, so.
I got you. So, but we're not agreeing, or we're not saying that he's got the full 60? Or are we saying that he's got the full 60?
He does, but he just
Okay,
has
all
credit
right.
for time served, yes.
Okay. You understand that, Mr. Graves? You're going to get credit for the 60 days? Okay.
Yes, thank you.
All right. So, Mr. Graves, with that amendment that you have a 60-day alternative sentence, but you have already served it, is this what you understand the offer of the Commonwealth to be?
Yes, sir.
You understand that your sentence in this case, if your probation is revoked and you have to serve it, will be consecutive with any prior sentence that you have?
Yes, sir.
All right. Or I guess I should say any prior case that you have, right?
Yes.
All right. Mr. Graves, other than the Commonwealth's promises as reflected on this offer, has anyone promised you anything to get you to plead guilty?
No,
Has anyone threatened you to try to make you plead guilty against your will?
no.
Are you pleading guilty voluntarily today?
Yes, sir.
Are you acknowledging, Mr. Graves, that on or about the 29th day of September 2019 in Barron County, Kentucky, you unlawfully took or exercised control over movable property belonging to Lowe's of Glasgow, valued at $500 or more, but less than $10,000, with the intent to deprive the store thereof?
Yes, sir.
Okay. Then, Mr. Graves, I can accept your plea of guilty here today. Let's discuss some things. First off, where are you planning on living in a long-term situation?
Louisville, Kentucky.
Did I understand that Mr. Brown said you got MRS? Is that right?
Yes, sir.
So are they going to be sending you to a halfway house somewhere?
I'm not for sure.
I guess what I'm trying to figure out, and I'm asking this more for the benefit of the probation officers on the call here. They can probably check, but they need to know whether he's going to be actually getting out of custody or whether he's going to be going somewhere straight from there, in which case that changes how they need to handle this. Can you tell, Brandon?
Yeah, so as I'm looking at it, he did get MRS, but he has detainers out of Madison County, Rowan County, and Nelson County that could be holding him in as well. So even if we do it today, he still may not get out.
Okay.
Maybe Amy can look at that and see if he has those things holding him. I don't know, but
I guess I just wanted to be sure that you guys were able to make contact with him, and if you know that he's going to be getting out or not getting out, it changes what you're going to be wanting to do. Can you tell, Amy? Are you listening?
I'm listening and I'm doing a report, Judge. I'm sorry, what was his name?
This is Brian Keith Graves.
Okay.
Senior.
I knew that at one point there were some bench warrants in other circuits, but I didn't know if he squared them out before he got here or not.
No, he had 14 cases. He's got several of them taken care of, but he's still showing, he's got a Jefferson County, but he was AR eligible for that one. And then the Rowan County is still showing $5,000 cash. He goes back to court May the 7th on that one. And
let me warn y'all something. If you ever meet somebody from Rowan County and you call it Rowan County, they're going to get really mad at you.
Oh.
They pronounce it in a way that it don't look like it is, but it's round, like round without a D on it.
I was about to interject that, Judge.
I'm just telling you, I'm not trying to embarrass you. I'm telling you so that if you ever meet anybody, you'll know to call it Rowan County because they'll get mad at you if you don't.
Yes, sir.
It's like if you go to, if you go to up to Hart County and you go to the Monroe community and, and they say, Monroe or vice versa, you don't want to say it wrong. If you go to Cleveland and you say it's Chalybeat, they're going to get mad at you. If you go to Albany and you don't call it Albany, they'll get mad at you. So I'm just trying to warn you, don't call it Rowan, even though that's how it ought to be pronounced.
Yes, sir. Well, let's just hope they don't add those to my 22 counties I came up with. He does have another Madison
County.
County.
Rowan either. It's round.
Boone County.
But that one has got unsecured. That one won't be holding him.
On that Rowan County, that 19 CR 251, when he came to us, he brought a bond on that case that he ROR'd on. And that's the same for Nelson and Jefferson and Madison. I've got bonds on all of his cases.
Okay.
Okay.
Okay. Well, good. Good. Yeah.
Does he have a hold from the DOC on this MRS deal? No?
Not that I'm showing.
Well, so Brandon, what do you want to tell Mr. Graves? Because we want him to be sure he's doing what you all tell him to do.
If they let him out today, he just needs to go straight to the office here in Glasgow and we'll sort out his transfer, where he's going to live, phone number, and all of that. Just before he goes anywhere else, just come straight to the office in Glasgow. Do you need the address, Mr. Graves?
Yes.
Bonnie, can you write it down for me?
Yes.
It's 100 Reynolds Road, Glasgow. And I'm also going to give you my state cell phone number. So if you were to have any trouble getting there, you can give me a call. It's 270-779-7369.
Bonnie, would you care sometime today to email me those bonds
I will.
so I can get him released? Thank you.
Like somebody hadn't been updating their computer in some of these other places. Pretrial computer. Not ours, of course. That's not what I meant.
Of course not.
All right. We've got Mr. Graves squared away then, right? I don't know if I asked Bruce or not, but I mean, did he say he wanted to go ahead and be sentenced today? We did talk about that, didn't we?
We haven't yet, but I believe he would. Is that correct, Mr. Graves?
Yes.
Go ahead and be sentenced now.
Yeah.
Yeah, I mean, we can do that and get you on your way to start taking care of business, okay?
All right, thank you.
All right, so that's a 4-year sentence. I'll grant your request for probation. There's a 60-day alternative sentence, which will do credit time served. You have restitution of $1,907 to Lowe's. What I usually do in that, set that at $50 a week. A month. You can pay more than that because at that rate, it's going to take you, 3+ years to get it paid. But you can pay more than that. But that's what we're going to start at least. And I usually let you have until the end of the first full month of you being out of custody. So, that'll start at the end of April when you'll owe your first payment. Okay.
Okay, thank you.
All right. And you can talk to your probation officer, whoever it ends up being, about that. All right. Anything else?
No, appreciate it. Thank you.
Mr. Graves, I'm going to give you credit on your fine and your court costs, and just call those served out because you've been in there for a while. Okay.
All right, thank you.
All right. Good luck, sir.
All right.
I think that's all I had, Judge.
Yep. Thank you.
Thank you.
That's the address and then the spring.
All right. Who you want to call next?
Yes.
Judge, I have Jay Hicks and Dion Wagner.
Okay. Let's call, I guess we can do Mr. Hicks. He's next on the list alphabetically.
That's my cases, Judge.
Judge, Greg informed me this morning we don't have an agreement in this matter. I've given Greg a offer to resolve all cases pending. Mr. Hicks did not take that offer. At this point, that offer is withdrawn and will not be offered again. We'll just say for the record that the offer I was making Mr. Hicks would be less than if he's convicted on that fleeing and evading case and found to be a PFO first degree. If he's convicted on that case and also found to be a PFO, he's facing a minimum of 10 years on that. And the offer I made was less than 10 years. So to resolve all cases pending.
Okay. You understand that, Mr. Hicks?
I didn't understand. I wanted to see it in writing. Mr. Berry come to me with 6 years one time, then he come with me with 10 years, and he come back with me 2 different times saying that I never had an offer. I want to see an offer. I don't know.
The offer is 7 years, Jay, to resolve everything.
I'm fine with that. I didn't know, he didn't explain to me about what's going to get, PFO is going to be dismissed. Honestly, he came to me with 6 years and then come with me with 10 years and then come back with me twice and met with me and said I never even had an offer.
Jay, I don't remember.
I'm confused is all. I'm done.
Okay, never mind. I'll be glad to come back and tell you again. Their offer is 7 years to resolve all cases.
Mr. Berry, would it benefit us to try to put him on Monday's docket where the paperwork, he he says, and I mean, we all know that the proof of the pudding is in the eating, as they say, but he says that he would accept that. Commonwealth could draw those up if they hadn't already, and you could take those papers right down there and he could look at them. And if he wants to accept it, he could put his signature on it, and on Monday morning we could do it.
I'll be glad to do that, Judge. Okay, yeah, I'll be glad to do that.
I mean, because I wouldn't just say it but Mr. Hicks is telling us that if it totals out to 7 years, he's willing to agree to it. Isn't that what you're telling us?
Yes. I mean, I would ask that the DUI be dropped. I mean, I don't know. See, there's a lot in it, and I don't know, when he just offered 7 years, I don't know what that means. Now I get to understand that it means that everything that I have pending would be 7 years. I'll run concurrent for 7 years.
Everything that you've got 4 cases pending in front of me right now, and those would all be resolved with that. I don't know about anything else you might have, if anything.
Well, see, in the beginning, I had quite a few misdemeanors that went along with it too, and it's not. There's a lot of stuff's not in my motion, so I didn't know what charges went where. Was they going to come back up? Because in these 4 cases, there's a few misdemeanors that go along with it.
Sure.
And I don't understand. You know, is any one of them going to be dropped, or are they all? You know, am I guilty of all of them? See what I'm saying? Because some of them
runs
can be
concurrent with any
restitution.
felony time that's taken.
Yeah, I mean, the misdemeanor time by definition runs concurrently with any felony time, so it wouldn't add any additional time. That, you know, there is a DUI in here, at least one. It has been my experience that unless they have lab results that exonerate you, they don't, you know, no prosecutors dismiss DUIs in plea agreements, except in a certain other county that is a republic unto itself that the rest of us can't get away with in other places out here in the hinterlands. You know, so my guess, without having seen any of this, is that there may be some wiggle room on some of these other misdemeanors, but the DUI is probably not going to be dismissed. And, you know, any of the other misdemeanors, they'll run concurrently, so they wouldn't add anything.
Right. Okay.
Now, if you have misdemeanors that aren't incorporated in these indictments, it might be different. But you do have a lot of misdemeanors that go along with these felonies, and everything will be wrapped up one way or the other if you plea in these felonies. I mean, those misdemeanors will all be taken care of one way or the other. They won't be out there left hanging, in other words.
Right. Okay, I understand.
All right. So we'll see you Monday morning.
Yes, sir.
All right. Thank you.
That leaves Dion Wagner for me.
Yep. I believe that's the last case I got anyway. Or
Last
last.
last time we were in court, said she was wanting to make a motion regarding bond.
Yes, that's correct.
All right. I'm metaphorically all ears.
Well, Your Honor, we've had some discussions back and forth, but we've not reached an agreement as of yet. So Mr. Wagner is presently incarcerated in Barron County Detention Center. However, I think you had given him a 45-day sanction for failure to pay restitution previously on some other cases. There's actually been at least one payment on those cases here recently. He has actually applied to DART, and I've learned that they've called him this week for an interview. So obviously if he can get out and get that job with DART, then he can start paying on the rest of the restitution owed on those other cases. I do understand, after looking at the pretrial rates, that, you know, the pretrial doesn't look particularly helpful to him. However, I will state to the court that I've discussed with Mr. Wagner the possibility of him being put on an ankle monitor, and he is on board with that. The court would allow him to get out on an ankle monitor, go to work for DART, assuming that he's hired following his interview. If he's not hired following his interview, he does have some other plans where he can put in for, but that would enable him to continue paying the restitution on those old cases, and he will comply with U-turn. I've spoke to him at length. He has a grandmother who's got some medical issues, and he's kind of concerned about her too. So I would request that the court at least allow him to get out on an ankle monitor so he can work, pay off that restitution that he owes.
Mr. Gardner.
Your Honor, the Commonwealth would be opposed to any, I guess, bond modification here. We have 2 18 cases that are still pending against Mr. Wagner. And the reason they're pending is generally we can't get him to come to court or, reach any type of resolution on this matter. And then also we have 2 a 19 and a 20 case. And obviously we've got 2 18 cases. He's picked up 2 new felonies as well since he's been on bond. And actually, since the first case, he's probably picked up 3 new felonies. I'm not exactly positive about the timing on the charges, but I know at least 2 new felonies since he's been on bond. Mr. Wagner's history with this court. I mean, he does nothing that we ask him to do. And I don't see that changing in the future, and ask that you keep the bond the same.
Your Honor, can I respond just real briefly?
Yes, ma'am.
And I know you've already heard me once, so I apologize. I will keep it real brief. The one thing that I thought was particularly interesting is that during all of 2020, there were no new felony charges for Mr. Wagner. So we know that he has the capability of being in the community and not incurring new charges. Now, I know that this court is well aware of his history, and he does have a history of addiction. I think that many of these charges that he incurred actually were in the throes of his addiction, but I don't believe he's actually had a new charge. Now, he did get indicted in 2020, early 2020, but that was based upon a charge from November of 2019. But he's went all of 2020 with no new felony charges. I think he's turned a corner and realized, sometimes with addiction, it takes more than one time before you hit the bottom. I think he's gotten to that point now, and I think he's gotten serious. He realizes he's got a grandma who's not going to be around forever, and he wants to take that job at DART. He's willing to wear an ankle monitor, and he really seems to have turned a corner and wants to comply with the court and get things squared away at this point. Now, we haven't reached an agreement on all those prior cases, but addiction does sometimes play a role when you have somebody who picks up 3 or 4 felony charges altogether. But at this point, I think he's been sober for some time, and I know he's not had a charge, or I've not seen any felony charge through CourtNet in 2020 other than an indictment that came late it wasn't late, but an indictment that came in early 2020, but that arose from a November of 2019 charge. So although he has a history, I don't think we should give up on his future. And I think that if he's got that potential to get that job and get it lined up, and he's willing to work and he's willing to wear a ankle monitor to show the court that he's serious about this, I'd ask that the court give him an opportunity.
Since Xanda had a second bite at the apple, I'll take mine as well.
Go ahead.
In 2020, the court is also aware that he's supposed to be monitored by U-turn, and the court's also aware the abysmal failure of his reporting to U-turn during that period of time. So we have no idea whether he was using or not using during that period of time. I'll just remind the court of that and leave it at that.
No, I mean, yeah. I mean, I know, I know everything that you already, and this isn't Miss Myers' fault. She just caught these cases, but I mean, I think Mr. Wagner been around long enough. I think he's probably had 3 different lawyers with the DPA, and they've all made, similar arguments because he does, as far as I know, you've been working most of the time when you're out, which makes it even more disturbing that you've got two of these cases that are 6 or 7 years old that you owe this money on and you won't pay it. I think one other time I let you out on an ankle monitor and you probably did okay while you were on the ankle monitor. And then as soon as we took it off, we were kind of right back where we started. First of all, the money that you're going to have to pay for an ankle monitor should be going to this restitution that you owe. And I shouldn't have to put you on an ankle monitor to get you to just do what everybody else is expected to do. So that's money that there's victims out there that have been victims for however long and hadn't gotten their money yet. And that's your fault, right? That's frustrating. I know that you've got family members that are sick and ill, and you've experienced some bad luck in that regard. But of all people that ought to be doing what they have to do to stay out of jail, it'd be people that care about spending time with their family that's sick and elderly. But I can't get you to do it, and you did make some payments on your restitution, but you didn't pay what you were supposed to pay. Your situation has been really frustrating to me because this is probably the third or fourth time we've been here in the exact same issue with you violating your bond and getting out. Mr. Gardner is correct. We had a hearing a month ago or whenever it was, and the testimony that I heard at that hearing was, I think that they called you 10 different times or approximately 10 times to come in for a drug test, and you didn't come for either of them. And that was after I let you out with an explicit conversation that you had to be monitored and get random drug tests. Yes.
I went to court in September, and then in October I had COVID, and I gave my last lawyer, Josh Spears, the papers of me where I had COVID that whole time. And then I just recently made those restitution payments. I'm trying and I'm doing everything that I can, like with my grandmother being sick and stuff. I went to court September, and then there was the 3 months later, like I came to jail or whatever. Like, I know what I did in the past, 18 and 19, like the suffering with everything and just being bullheaded. Like, my responsibilities have changed. And like now I can't screw off everything. You know what I mean? Like, it was just a situation of me taking care of my grandmother and the COVID and stuff. That's why.
Well, you couldn't blow it off before either, but you did, and that's why you went back to jail.
And I understand that, sir.
You're more stubborn than I am.
My priorities are different like now. Then back then, my grandmother wasn't sick then, and then my kids, I established a better relationship with my oldest kid while I was out, and then me not paying my restitution, and then me getting indicted or whatever. This last time, basically what brought me back in. Like, I wasn't out committing new crimes or none of that. Like, I just asked if you please give me another chance to get out. I know you heard that before, but like, I don't have much longer with my grandmother. Maybe 6 months, if that. And I had a payment made this week on restitution. If I can get out on an ankle monitor, I'll prove to you. And that's the only thing I can say, please.
All right.
I've been in here 60 some days.
Well, listen, I understand that, but I want you, you don't have to agree with me, but you've earned that 60 days in there. So I'm not going to, I understand you just telling me that for a reference, but I'm not the one that is the reason you're in there. You're in there because you didn't do what you were supposed to do. Okay. And it's part of the problem in these cases is that people don't like to acknowledge, well, let's don't talk about that, but don't blame other people for not doing what you're supposed to do. Okay.
I apologize for that. Everything is my fault. I can't blame nobody else. I just asked that with regards of me at least trying, and then with my grandmother, that I get another shot, at least on ankle monitor, so y'all can monitor everything that I do. And then if I can get out and at least make these payments and stuff. I've got my stimulus check. I got a $1,400 stimulus and my $600 stimulus out. And as soon as I get out, I can at least pay the restitution that I owe 900 on. I can pay that off, and then make payments on the other one. Like I've got to interview at Dart.
All right, here's what we're gonna do. Amy,
Yes, sir.
this is what we're doing with Mr. Wagner. All right.
Okay. Uh-huh.
He's got bonds in each case, they're cash bonds, and he hadn't made them. So I would be willing to do the following. All right. I would be willing to, I don't want to, I guess I'm going to have to do an ankle monitor because that's really the only thing that's going to make me feel comfortable. I mean, I shouldn't have to do that. And again, that's money that you ought to be doing something else with, even if it's taking care of your grandmother with. But I mean, you know, you've put me in a spot where I can't trust you without something like that.
Yes, sir.
I'm gonna, I'll unsecure these bonds on the following conditions. Number one, that he gets fitted with an ankle monitor. I don't want him on house arrest. I just want him on a curfew, which will, you know, I want him to be able to go to work. And if he gets a night shift type of job, then we'll work around that, you know, with curfew. But other than that, I want him to be on a 8 p.m. to 6 a.m. curfew.
Yes, sir.
Except for work. I want him to meet with his attorney. I'm gonna put him on for May the 24th for a pretrial at 1 o'clock. I will consider if there hadn't been any violations or problems, and if he's paying restitution like he's supposed to, I will consider removing his ankle monitor at that time. And the only reason I'm bringing that up explicitly is so nobody has to file a motion for it, or, you know, there won't be a question of whether, you know, anybody was on notice that was going to come up, and it won't require anybody to show a change of circumstances or anything like that. I'm explicitly putting it on with the understanding that if he can do that 60 days or so with no problems, then I'll be convinced to give him a little bit more lead. Okay.
Yes, sir.
Mr. Wagner, I want you to obtain and maintain full-time employment.
Yes, sir.
Pay restitution as previously ordered.
Yes, sir.
No violations of the law, penal code, drug, alcohol use.
Yes, sir.
Right. As
Yes,
part
sir.
of your monitoring, you could be subject to random drug screens as part of your monitoring through the U-turn with the ankle monitor.
Yes, sir.
All right. And again, I want you to be talking to your attorney because Mr. Gardner's point is very well taken. I mean, a couple of these cases are more than 3 years old.
Yes, sir. And I apologize.
Huh?
Let's say I apologize to the courts, and I apologize to Mr. Gardner too for giving him so much trouble.
We don't have to apologize anymore. Just don't do anything else going forward that you have to apologize for. You understand?
Yes, sir.
Because an apology is pretty cheap at this stage.
Yes, sir.
I mean, in the future.
Yes, sir.
I appreciate your willingness to apologize. I'm not trying to take that away from you. But I mean, going forward, apologies are not going to count for much, okay?
Yes, sir.
I mean, keeping your nose clean and doing what you're supposed to do is what's going to count.
Yes, sir.
All right?
Yes, sir.
And I know that you've told me all this before. Your previous attorneys have told me all this before. I don't think you've probably been in there this long. And I think that, you know, if I hadn't made my point by now, then anything else pops up, I won't consider that there's really any way to make a point. You know what I'm saying?
I agree.
And I'll just have to consider you a menace to society being out on bond, and I'll just have to pull it.
I agree, sir.
Okay?
Yes, sir.
I mean, your attorney is correct about several things, but certainly one thing is you do have the ability to do a lot better than you have done. You
Yes,
do
sir.
have the ability to live a law-abiding life without committing crimes.
Yes, sir.
You do have the ability to pay restitution because you've shown me that you can,
Yes,
but
sir.
that cuts both ways. That also means if you don't do it, there's a basis for me to find that you're just flat out refusing to do it.
Yes, sir.
And that's whether it's live your life right or pay your money you owe or any of those things,
Yes, sir.
you know?
Yes,
And
sir.
we've still got cases, all these cases that we've got to answer for or work out or resolve in some way. I don't know what the appropriate resolution is. I haven't, I'm not in your negotiations and all that, but I want you to stay in contact regularly with your lawyer because, you all need to figure out whether you're going to, you know, how you're going to proceed on these things, and we need to go ahead and make a call one way or the other.
Yes,
All
sir.
right.
Yes, sir.
All right. So
Judge, I would like to address as far the, I know this has popped up in the past here when he's, you know, provided, or actually whoever his employer was contacting Tyler and saying he couldn't be in court for this or that reason. I don't want that, you know, on the 24th, you know, we come to, whether it's in person or Zoom court, and Zanda says, well, I've been contacted by somebody and they said, you know, he couldn't be here today. Obviously, if, you know, he gets a job at DART and there's a situation where he's going to lose a job if he's going to be in court, I'll be, you know, agreeable to that, to move it to a different day. But I'll be asking for his bond to be, you know, revoked if he's not there on the 24th.
Yes, sir.
yeah, I mean, you know, you get a one free bite, you know, type of rule. I mean, you know, you get a move if it's necessary under the circumstances and all that. But if you get this job, you're going to be 60 days almost into the job by the time that gets there anyway.
Yes, sir.
And you know, we went through that all fall, and you may have given Tyler, or I don't know if you gave anybody anything, but I mean, all we kept getting was your boss was calling and saying, well, he can't come to work. He's quarantined because we worked at a job where somebody had COVID. And then the next, we put it off 2 weeks. And then the next 2 weeks it was, well, he can't come to work. He's out of town. And then it was, you know, we were getting every excuse in the world, but what felt like the truth. And, you know, we're going to have to get the truth from here on out. Okay.
Yes, sir.
All right. I will see you on May the 24th. And just because Mr. Gardner brought it up, I anticipate that we are going to be meeting in person on May the 24th.
Yes, sir.
And I anticipate that I'm going to see your shining face here in the courtroom.
Yes, sir. What do I need to do as far as the ankle monitor? Like, I need to get a hold of my family or
You're going to need to line up the money end. We're going to notify the people that do the ankle monitors, and they'll get in touch with you over at the jail. Or
today, or
they'll probably do it today. I mean, if they don't have any monitors available, which is unusual, it might be tomorrow, but usually they do it the same day that we contact them.
okay. I had this real quick. I have well, my fiance's address, and then I have my grandmother's address, but I plan on going to my grandmother's address. If it's not going to be no complication if I choose either or, as long as you have the correct address.
You just need to choose one.
Okay.
Okay.
All righty.
I want them to know where you are when you lay your head down.
Okay. All righty.
All right.
All righty. Thank you.
All right. See you in 2 months.
Thank you, Your Honor.
All right. You're welcome.